Hello, my name is John Smeaton, and I'm delighted to welcome you to the Family and Life Academy. This year, the Family and Life Academy has been building educational resources for the defence of children, both their physical and spiritual defence, with a recent webinar by Dr. Pat Fagan on the transformative effect of marriage and religious worship on children and society. And even more recently, another by Jennifer Roback Morse on how the targeting of children is an essential and increasingly prevalent tactic of the sexual revolution lobby. Today, continuing with the defence of children, we're joined by the founder and president of Catholic Action for Faith and Family, Thomas McKenna, and by the distinguished attorney Paul Jonna for an exploration of the historic overturning of Roe v. Wade 1 year ago today, and its significance for the battle against legalized abortion, in particular in the US. Paul Jonna, together with his law partner Chuck Melandri, are the legal counsel for the Thomas More Society, a Catholic public interest law firm in the United States which specializes in defending the rights of unborn children, families, and people of faith. Melandri and Jonna LLP have won decisive victories in the pro-life and pro-family cause, so we are very honoured to be able to hear directly from Mr. Jonna today. Likewise, Mr. McKenna has accrued great expertise in today's subject through his work with Catholic Action for Family, Faith and Family. So, without further ado, I will hand over the stage, firstly, to Thomas McKenna, who will be talking, as I said, to Paul Jonna. Thank you.
Well, John, it's a great pleasure to be speaking with you today and addressing all of your followers. This is indeed a very, very important day in the history of our country, United States, because it marks exactly today 1 year to the day that abortion at the federal level was overturned in our country. So I'm glad that we're able to address that, and I'm glad to be here with Paul Jonna. Paul and I are both from San Diego, California. We're colleagues. Paul's a lawyer, as John mentioned, but we do work together on different issues that are so important to our cause. So I'm very pleased to have you on today, Paul.
Thanks for having me, Thomas. It's great to be with you.
Well, I just thought to start with, again, we're going to focus mainly on the United States because that's the issue that we're talking about. And one of the things I just thought, for many people may not know, where are we 1 year out? So I wanted to just give a little introduction with a few statistics. People might be wondering what has happened since Roe versus Wade was overturned. Where are we at the states? Because as we know, that put the law back to the states to decide on an individual state level what it is. So where are we today? But basically, we find that in the United States, it's split. The country is split. We have about 25 states that have abortion on demand, and we have about 25 states with varying different limits on it. Many of them, very advantageous. And calculations of at least surgical abortions, it's figured that maybe in the last year, 25 to 26,000 children were preserved from death in their mother's womb because of these laws. So what do we have today? Basically, we have 8 of those states that have enacted laws. They have been held up now because of injunctions by federal judges. We've got judges that were appointed by liberal administrations, and there was a vote to enact this, and the judges have stopped it. So that's 8 of those 25 states. 10 of those states has abortion is not allowed unless it is for the benefit of the health of the mother. Okay, we as Catholics do not agree with that. There's a lot of controversy, but I'm talking about where do we stand with the laws. We have 4 of those states have prohibited abortion, but they do allow it in the case of rape and incest. We know that that's been a case that the other side uses a lot. But these, again, even though they still allow that, abortion on demand is no longer allowed in those 4 states. And then the other 4 states, They have different degrees of various gestational limits on abortion. From in Georgia, the state of Georgia, it's 6 weeks, and in the state of North Carolina, it's 20 weeks. So that's where we kind of we see today, and that's where we stand 1 year later. So with that, I just Paul, as the legal team here, is going to talk about where we stand, because that's really what the point of this webinar is to see where are we at, how did we get here, and where are we going to go. So Paul, I'd like to just start by saying that on this 24th anniversary here, the good news is, of course, we talk about the way forward from here. I just want to ask if you could give us a little of the legal background to this watershed decision, which, you know, some people, it was, you know, 50 years, and people thought it's never going to come. You know, those in the pro-life movement, we always fought for the pro-life, we always marched for life, but after so many decades, it was really, really amazing that this was overturned. So since you're on the legal front of this, Paul, I'd like to get your ideas on a few of the legal issues surrounding this Supreme Court landmark decision. So with regards to the recent Dobbs decision overturning Roe versus Wade, what was the specific process that led to the reversal of Roe versus Wade?
Sure, Thomas. So one important background point for viewers to keep in mind is under the U.S. Constitution, there's certain areas of law that are reserved to the states, and on the other areas to the federal government. And the 10th Amendment kind of says this. It says that powers that aren't delegated to the states by the Constitution are reserved. So before Roe versus Wade in 1973, regulation of abortion was really a state issue. And there were a lot of states that had strong laws prohibiting it, and some states allowed it. But what the Supreme Court did in Roe versus Wade is they stepped into this and they took the issue away from the states. And it said that women had a constitutional right to obtain abortions under the 14th Amendment's protections for liberty. So basically, the Supreme Court invented a right, and they set up a trimester framework, and there were different rules about how a state could regulate abortion in each trimester. And it was a very unusual opinion. And 20 years later, they had a chance, the Supreme Court, in the famous Planned Parenthood versus Casey case, to take a second look. And we had a strong Supreme Court majority, and everyone was optimistic and hopeful that finally Roe versus Wade would have been reversed. But tragically, that's not what happened. And they created another funky test. The Supreme Court was unfortunately too afraid of political backlash, but they modified the trimester framework into a pre-viability and post-viability framework. And basically what they said was pre-viability, which is normally around 24 weeks, governments could not impose an undue burden on a woman's ability to access abortion. So that was the law of the land for a while, until we got to the Dobbs case. And in a nutshell, what happened in the Dobbs case is that Mississippi passed a law that would ban abortions after 15 weeks, except for cases of medical emergency or severe fetal abnormality. Under the Casey framework, that was an invalid law. So it was challenged by this abortion clinic, and the district court and the conservative Fifth Circuit both struck down Mississippi's law, and went to this U.S. Supreme Court in May of 2021. And it wasn't taken up to decide whether to overrule Roe or Casey. It was taken up on a very narrow issue, actually, which was to decide whether all pre-viability abortion bans are necessarily unconstitutional. That was the question before the U.S. Supreme Court. So it could have been the case that a 15-week ban would have been okay if women still had a realistic chance to get an abortion by the time, if they wanted one. And so at this time, the Supreme Court was majority conservative. We had Justice Kavanaugh, who joined the bench in October 2018, and Justice Barrett in October 2020. But when Mississippi petitioned the Supreme Court to take this case, Justice Ginsburg was still on the bench. But when the Supreme Court actually agreed to take it, she'd been replaced by Justice Barrett. The Thomas More Society filed 3 amicus briefs, and it seemed that those influenced the court. But basically, in a nutshell, what Justice Alito did on behalf of the court was he completely overruled Roe and Casey. And he said, the Supreme Court said the question of whether and how to regulate or ban abortion is left to the people of the states. He said that Roe was egregiously wrong. Its reasoning was exceptionally weak. And it's a very straightforward analysis. It just says the Constitution does not mention a right to abortion, and it can't be inferred. Justice Roberts, he would have kept the this 15-week ban, but he would have not overruled Roe and Casey. Something that no one really picks up on, which I think is fascinating, is that the clinic that challenged this law in Mississippi only did abortions until 16 weeks. So this law, keep in mind, in Mississippi banned abortions after 15 weeks. So this whole big fight in Dobbs was over a 1-week difference. So I think it's something that's lost in the story. But obviously, Dobbs falls short in a very crucial respect, Thomas, by not saying that the unborn are persons who enjoy constitutional right to life under the Equal Protection Clause. And that's a great argument, but only Justice Thomas was willing to go that far.
Yes, it's quite interesting, Paul, that you bring up that point. For 1 week. I think it was kind of providential, or the other side, over 1 week. If they had known that what the outcome would have been, I think they would have just, they wouldn't have brought it up.
I think it's an example of the devil overplaying his hand. I mean, they clearly didn't have the right makeup of the Supreme Court, but beyond that, all of this legal challenge for a 1-week difference, I think, it was a gross error on their part, but obviously it worked out very well for the.
Well, and I think part of that was, like I mentioned before, that since it was like abortion was enthroned in our country, that it's decades here, it was never ever going to go away. And I think that was the shocker for people. And I think that for us is, for those who have stayed firm in the pro-life movement, those who have prayed and fasted and gone to sidewalk counseling, I think that was a sign that there is hope. When it looks like there's no hope after 5 decades, you'd say throw in the towel. And the other side was waiting. That's what they always were saying. This is a done deal. And here it turned around, unprecedented. So I think that's it's a good for us to remember these things, that there are victories when it looks like victory is not going to be able to come.
I think the message from God here is very loud and clear. Never give up. Keep fighting. We don't know when we're going to win these battles. It'll happen in God's time. Our job is to just fight. And as Mother Teresa famously said, we're not called to be successful. We're called to be faithful. We just have to do our part, and God will do. God will. Yeah,
and that slogan of Pope John Paul II, "Be not afraid." I think that's what, from today, facing this, we have to keep that in mind. And Paul, I wanted to just say that, because the court reversed such a decision after so long, what would you say to those who say the courts are becoming a reflection of the political divisions in our country?
Well, I think Roe is actually the best example of that. I mean, that Roe is kind of what made that problem a lot worse. Courts are not supposed to be this issue of judicial activism, inventing rights that don't exist. We saw the Supreme Court going down this path with a number of cases, inventing out of whole cloth rights that are not mentioned in the Constitution. And so Roe really set a very bad precedent in that regard. And then we saw that tragically with the Obergefell ruling, basically undoing laws in many, many states and providing for some kind of supposed right in the Constitution to gay marriage. So, but I think the Dobbs decision is really a huge step in the right direction in terms of forcing courts to take a second look at what they really are supposed to be doing. They're not supposed to be, creating laws. They're supposed to be interpreting the U.S. Constitution. And so this issue is a real issue, and we look at every case. Unfortunately, we have to look at who's appointing the judge in our case and whether that's going to have an effect. But it's great that the Supreme Court took the very unprecedented step of reversing itself, and it's a very positive step in the right direction in the United States.
So, Paul, one of the accusations from the other side, from the left and from feminist movements, what they talk about, and we've seen it in the news recently, because when they see they don't have the principles to push back on, they start bringing other issues that really aren't tied to this. But one of the issues that comes up, and I'd like to know what you'd say about this, is they're saying that basically this reduces women to second-class citizens because it takes away their right. That was one of their points of the pro-abortionists. a woman has a right to do with her body what she wants. And so by now taking away that right, once again, you've relegated women back to being second-class citizens. What would you say?
Well, the opinion in Dobbs actually addresses that issue somewhat. Various prominent jurists, including the late Justice Ruth Bader Ginsburg, said that they would have grounded the right to abortion in the Equal Protection Clause of the 14th Amendment, not the Liberty Clause. And they basically said, without access to abortion, women are not fully equal. And because this is an argument that was raised by important scholars, Dobbs directly addressed it. And what they said was in the Dobbs decision that simply because only women obtain abortions doesn't mean that abortion is a woman's right issue. And if the purpose of restricting abortions was a pretext for discriminating against women, that'd be a different story. But millions and millions of women are pro-life, and they don't view banning abortion as a way of discriminating against women. So I think the Dobbs decision dealt with that issue well, and it's really a non-issue.
Yeah, we really see how this Dobbs decision brought up for clarification some of these issues, which for us was frustrating that decades, since you and I were, even little children, this was precedent already. And so I'm just really inspired to see what took place here. Regards to the Supreme Court, I remember some time ago when Justice Alito was going through his confirmation hearings, and then the Senator Arlen Specter held up a sign and called Roe versus Wade something like a super duper precedent. Judging by the apocalyptic reactions that we saw of abortion supporters after the Dobbs decision, you'd think that this was the first time that the court had reversed a pronouncement, a decision that was made. What does it say about our Constitution that the Supreme Court can actually overturn one of its own previous decisions?
It's interesting because a lot of how the Supreme Court works is not in the Constitution. It never says, for example, that the Supreme Court is the last word over Congress and the president, and even prior Supreme Courts. The Supreme Court itself said that. It said it was the last word on who is the last word, and nobody can tell them otherwise. But practically, the Supreme Court acts very slow and deliberately, and it would be dangerous for our republic if it acted too quickly. It's dangerous to our democracy if people lost faith in the Supreme Court, which is partially what happened when the Supreme Court acted too quickly, as I said, in recognizing gay marriage. But there was there have been a handful of other famous reversals, including, Plessy versus Ferguson, which was reversed by Brown versus Board of Education, where the court found that racial segregation violates the U.S. Constitution. Separate but equal is inherently unequal. So it's good that the Supreme Court can reverse itself when it's wrong, but it's also very good that it's exceedingly rare.
Well, and yes, that's a good point. It's rare. You can't have a court that's reversing itself. And then if you look in history, it is rare, but it's always been on very key issues.
Yes. Yeah. And
so what is your opinion, or what do you see the scenario where we are today? Could it possibly, or what are the thoughts or possibility about this law being overturned again in the states, the federal government, saying that the federal government had the right to regulate abortion? Do you think that's in the near future?
Oh, no, absolutely not. I mean, it's so rare. In the history of the Supreme Court, I think there have only really 3 or 2 other times, so 3 total now, where the Supreme Court reversed itself on a matter of this magnitude. It's obviously possible, but very, very unlikely. And remember, we thought Roe would be overruled in Casey because we had a conservative majority, but that didn't happen. And Roe would not have been overruled in the Dobbs case without a supermajority, basically, of conservatives, 6-3. So the biggest threat, I think, is this talk about packing the Supreme Court, which if the Democrat Party had full control of Congress and of the executive branch, then there's talk about that, and that could really cause lots of damage. But as far as with the current makeup of the court and with the current structure we have, we need a super majority of very liberal justices, and they'd probably want to wait a long time before they do anything like that.
Yeah, because it brings insecurity. If we go back and forth, it would bring in insecurity, and like you said, that would damage the republic.
Yeah. It would undermine the credibility.
Yeah. So another interesting aspect of this was that Justice Clarence Thomas, with his concurring opinion, he stated that he wants to review previous Supreme Court decisions regarding contraception and gay marriage. These are interesting and hopeful signs, but are they realistic possibilities going forward? Could these issues, do you think the Supreme Court could come to look at contraception, the right to contraception and the right to gay marriage?
Well, first of all, let me just say, I think Justice Thomas is absolutely correct. If you just follow Justice Alito's reasoning, why they reversed Roe, I mean, basically it's because the Constitution doesn't provide for that right. And the same exact reasoning applies to contraception and gay marriage. There's nothing in the Constitution that provides that right. That should be left to the states. As I said, the federal Constitution, only encompasses matters that are that the states don't have authority over. So that reasoning would definitely apply. But with the current makeup of our court, he was the only justice willing to go that far. I think it would take, it took Roe 50 years for Roe to get overturned, and we needed time for the pro-life movement to grow and for hearts to change. Justices Gorsuch, Kavanaugh, and Barrett, the ones who made the real difference here, are all in their 50s. They weren't even lawyers when Roe versus Wade was issued, but they grew up with the pro-life movement. So I think we'll probably need another 50 years to get Obergefell overturned when the children growing up now with same-sex marriage around them, and when they get on the court and say that through their lived experience that it should have never become the law of the land. So it's something to hope and pray for, but it's not going to happen anytime soon.
Another aspect that is kind of really tragic with the advancement of abortion is regarding chemical abortions that we know today are really, it's becoming, more and more rampant. And, many of the pro-lifers in the pro-life cause, and I think it's true, have said that abortion numbers were, going down. We heard that statistics where they were going down. But that wasn't so much because there were fewer abortions, but it was because there were fewer surgical abortions, but there's more abortions, chemical abortions, the, Plan B pill. What they now call a chemical termination is nothing other than a deadly combination of abortion pills that can be prescribed by telehealth. You don't even have to go into a doctor's office, and appointments, they can then mail you directly the chemicals, the pills, to abort the baby in your home, which, it's just even more, I find it just even more egregious that, you would leave a mother by herself in her home to abort her baby. It's just even worse. So they would allow this up to at least 10 weeks. If this is really true, what can be done about the chemical abortion from a legal standpoint, or is there anything? What do you see in the pro-life fight to address this chemical abortions that are becoming so rampant?
Yeah, first of all, let me just say, these are very dangerous drugs. And during COVID, we saw that they used the COVID as a justification for lowering a lot of the requirements, allowing them to be prescribed via telehealth and mailed. And so there are a lot of creative ways that we can attack this issue. Some lawyers have already filed a case against the FDA saying that their approval of the abortion pill was rushed for political reasons, ignoring legitimate safety concerns. And the district court agreed. They struck down the regulatory approval of the abortion pill, but unfortunately, the U.S. Supreme Court stayed enforcement of the order pending appeal. They didn't reverse it, but they just put it on hold. But that issue is working its way up through the courts. And there's actually a law on the books. It's the Comstock Act of 1873. And it's a federal statute that criminalizes sending abortion pills through the mail. And it was basically ignored when Roe versus Wade was the law. But Thomas More Society affiliated attorneys are using that law to challenge groups that are mailing the abortion pill. And if a Republican president were in office, they could enforce this law. The Biden administration is not enforcing it. It is on the books. It's a valid and legitimate way to restrict this. And so there's also lots of other creative ways groups are challenging sending abortion pills across state lines. For example, Thomas More Society has a wrongful death case where a woman obtained an abortion over her boyfriend's objection by getting the abortion pill delivered to her across state lines. And the boyfriend isn't suing her. but he's suing the group that gave her the pill, saying that they're liable for damages for the loss of this child. So there's a lot of ways that the good attorneys on our side are addressing this, and so there's reason to be optimistic.
Paul, you mentioned that they were using, there was a law from the 1800s. What was that back in the 1800s? Did I understand that correctly?
Yeah, it basically prohibits sending by mail all kinds of different things, and it's a law that it's kind of a broad law, but very clearly would encompass abortion pills. It basically was passed during an era where there was a greater focus on moral issues, and there was certain things, including pornography, including other things that were not allowed to be transmitted via mail. And so it is very clear, and I don't have the text in front of me, that abortion pills would fall into that act, but it's basically been ignored, and any Republican president could legitimately enforce it.
I think it's interesting how, with talk about, health issues and, all that today, and I've spoken to many physicians about this. My wife is a physician. She's, OBGYN. That this is very, very dangerous from a medical perspective. I mean, abortion in any case is a procedure that is dangerous. So to have the idea now that they're going, I mean, it's not just you go in and a doctor prescribes it. That already is dangerous, that you take your pills and go home. Now they want to do this. They're proposing to do this by telehealth. You call up, or they're talking over the counter, that anyone can go in and obtain these pills. That's where they're going. And it's interesting how the common sense, or the well-being of the woman and the child, the well-being is dangerous. I mean, it's really amazing to see how laws are being enacted or being pushed that go directly against the good health, the good reason, the Hippocratic Oath, do no harm. How can you give some pills, mail some pills, you don't even see the patient, and say, here you go have an abortion?
And my understanding is that these are not regular pills. These are in a class of pills that are among the most potentially dangerous. So there's heightened standards that are supposed to be in place for pills in this category, and it's very dangerous to women. And many women have been injured or killed from, the side effects of these pills. So it's a very big safety issue.
I think that's important. What the way to push back for the health and well-being of women and these babies is through the legal system. I think it's interesting how it's come down to the law of the land, and we see that we have to base ourselves on that. So that's the great work that you're doing with your Thomas More Society. You're on the front lines, and kudos to you. Those Americans, we support you, and that's just so important. That's where we have to push back. With regard to the pro-life legal and activist strategies that are going on, we all know that abortion obviously is not a settled decision, and it's been put back to the states. Here in California, our state laws are very permissive. Our liberal governor Newsom, is even proposing that the state fund abortions for women coming from other states where it is illegal. And he's also proposing that the people of California, pay for the transportation of those places for those women to come here. And he's, calling this a safe haven for abortion. I mean, something just unfathomable. Anyway, the question here, while all of us in this pro-life movement are seeking complete and equal protection of children, today where we are, where do you think the immediate focus needs to be, like addressing this to push back? What do you see is urgent and the most advantageous?
Well, yeah. In California, in places like California, the focus really needs to be on creating breathing room for efforts to change the culture. The laws in California are not just permissive to the pro-abortion side, but they're hostile to the pro-life side. And I know in Los Angeles, Oakland, San Francisco, they all have ordinances that are aimed very clearly at shutting down crisis pregnancy centers. So we haven't seen those actually enforced, but if they are, we'll definitely need to fight back against those. And on school campuses and other places of learning, we need to make it so that pro-life message can get out there and not be censored, because it's a very compelling message, and one that really can change hearts and minds if it's allowed to be out there. And so we're seeing increasing censorship and hostility to just having that view shared. So I think a critical thing is fighting back on those two fronts for now.
And so you see that there is precedent that we can push back on these at the state level now.
Oh yeah, absolutely. I mean, basically, there's going to be strategies in these blue states like California and strategies in the red states. And in the blue states, there really are pushing the envelope as far as they can, and they're going to need to be, you know, held accountable when they're crossing the line. And there is a lot of damage they can probably lawfully do now because, again, the states get to regulate this issue. But in California, especially in states that are very extreme, they're definitely going to be crossing the line all the time and try to get away with as much damage as they can.
And that gives you gives you hope.
Well, it gives hope that we are optimistic because we know that the truth will ultimately prevail, that there are still good judges in states like California. There's still common sense and truth will prevail on the pro-life side. It's going to take time. We're going to need to fight this state by state, battle by battle. I'm optimistic because we see that most Americans, 2/3 of Americans, are largely pro-life now. I mean, the views are changing on this issue. So you have some extreme people running these liberal blue states, but most everyday folks are starting to realize how terrible this is and how rare it should be. So I do have some reason for being hopeful, but it's going to be a long, drawn out
Well, and
battle.
I think what's interesting too is as we progress, something that's been, I think, again, so providential, as medical technology has progressed in, you know, everything we know it as, it has come to show with the ultrasound, the simple thing of the ultrasound, how that changed things. It proved through medical implements that we can know when a baby has a heartbeat. And that was the beginning of so many states now that were able to implement those laws because of the medical technology. And I think that's something, you know, we have to see that that's the hope for us, that, you know, who thought, you know, as they're developing more and more, you know, techniques, some are using them for abortion, but even for our side, I think that's so important. And again, it's another aspect that gives us hope that other issues will come up that we can use for that.
Yeah, I have friends that are involved in raising money to buy mobile ultrasound clinics, and those, you know, women who want to get an abortion, who get a chance to see their baby on an ultrasound. I mean, that makes a huge difference. Little things like that in any state can make huge differences, and so that kind of thing needs to happen on a bigger scale.
Of course.
Wow. Well, look, this is the point when I say thank you, Mr. Jonna. Thank you, Mr. McKenna. And my cue here is to say let's go on to the questions. But I really must pause to thank you for this really illuminating presentation that you've made. It's been a real gift to the visitors of the Family and Life Academy. So it's so good to weigh up a year later, you know, and that was reflected in the calm and measured presentation. I mean, I hadn't realized that Dobbs addresses head-on the issue of women's rights. That's really interesting and not unimportant for people in other parts of the world. And if I may say so, you know, I'm based in Britain, but in Britain and in Europe generally, as I'm sure you're aware, there's a big attack on the right to be pro-life, on the right even to pray silently outside an abortion clinic. And so, Mr. Jonna, when you were saying there that, you know, the focus needed to be on, you know, the freedom to get on with spreading the pro-life message, I think that is spot on. And with tactics like that, I'm really hopeful, more than I was before this webinar, that we shall make progress.
Well, I think, John, I think that should give you hope. You know, as you recall, I visited England for the first time last August, and it just for some meetings, and it just coincided with when I was there, as you had your annual March for Life, And
Right.
I remember the enthusiasm, and it was the largest crowd ever they said in history in London. It was downtown London. And I saw the enthusiasm, and I know that that's what the speakers, the people I was talking with, and the speakers said, the decision to overturn Dobbs in the United States gave us hope, because when nobody imagined after decades and decades, 50 years. So there is hope. There's hope, although we don't see it, as I said before, be not afraid, but we see hope for, countries like England, Ireland, where in Europe, where, it's scandalously, we see pro-abortion in countries that should be Christian Catholic. So I think that's, what we should share with also with you, is there is hope. We didn't see it here, but it was overturned. So, we stand with all of our brothers and sisters in Christ throughout the world who are pro-life and who are there to defend it. So I just want to thank you for all the good work that you've done for decades, defending life in Britain there. And I think it's so important. And, the others that have picked up the standard that are carrying it for you there, we have to work together whenever we can. And again, we should always have hope.
Indeed. Now, there are a few questions, I have to say. And the first one is a question from one of our viewers. Isn't Illinois already funding abortions of women from other states? Apparently, Governor Newsom is proposing this.
Yes, Governor Newsom. Well, the situation in California is pretty bad. He wants it. He says, as Thomas mentioned earlier, California to be an abortion sanctuary, and the voters, though, tragically passed Proposition 1, and there was already a statutory right to abortion in California, but now the Constitution itself will include a right to abortion with no gestational age limits at all. And so basically Proposition 1 attempts to legalize late-term abortion at any stage of pregnancy. And he also signed a package of 13 extremely radical pro-abortion bills last September. And basically, I won't go through everything they do, but I'll just highlight. They legalize, it seems they legalize infanticide. They create a state abortion fund to pay for abortions. They create a scholarship to fund the training of abortionists. They create the platform abortion.ca.gov for people to find abortion providers. They shield women from liability who travel from out of state for abortions. And in California, thanks to one of these bills, there'll be no criminal abortions as long as the woman consents. Coroners don't even have a duty to investigate. So, and now we're seeing late-term abortion clinics opening up pretty soon. They're going to commit abortions. This DuPont clinic that's coming to LA will commit abortions up to 32 weeks. And so the situation in California is quite egregious. And so we need to monitor everything that's happening and be prepared to file lawsuits. And so it's important that there's, law firms doing this work, but obviously it's a multi-pronged battle. The law firms can only do so much. There's a cultural battle, and people are being deceived on a massive scale. And on a personal level, the easiest way sometimes to be a witness to this issue is to just have a big, Catholic family and walk around and show people the beauty of family life. I mean, you can change hearts and minds in those small ways. I mean, you see a lot of couples walking around with their dog and no kids. It's very sad, and I think that it's very important to show people the joy and the happiness that living the way that God wants us to will bring. And so that's another big important message, I think.
And Paul's a good example of that. I want to congratulate him with number 8 on the way. He's a good example on the front line of pro-life families.
Absolutely.
Yeah.
I've got another question here from someone. Are chemical abortions somehow bypassing statewide restrictions which have been enacted since the Supreme Court decision?
Statewide restrictions since the Supreme Court decision. I'd have to know which restrictions we're talking about, but the FDA sort of sets the standard in terms of what's, a lot of these issues are decided at a federal level when it comes to medications, but I'd have to look at the state restriction. But if there are state restrictions that can be enforced, then I'm sure, in those red states, I'm sure there'll be fights on those fronts too. I'm not aware of which ones would apply where I'm from in California, but that's a good question. I just don't happen to know if there's any specific ones that would apply. I'm not sure if you're aware, Thomas.
No, I'm not.
Well, thank you. Obviously, an interesting question. Here's another one from one of our attendees. Is an unborn child recognized as a person under United States law?
It's interesting because, there's different state laws. For example, if you kill a mother and her fetus, it's a double homicide in California. And the way that statute is written is that the killing of a fetus is murder, unless the mother consents. So, I mean, conceptually, the way this seems to work is to recognize that a fetus is a person, but to elevate the mother's right to bodily autonomy or privacy over the right of the fetus in every case. But as a general rule, no. California does not view unborn children as persons, but there are great arguments that they should be. And the 14th Amendment to the U.S. Constitution was ratified after the Civil War, and it says that no state shall deprive any person of life, liberty, or property without due process. And many professors in the Dobbs case submitted amicus briefs, and they made a very compelling argument that person in this context includes the unborn, because around the time of the Civil War, the 1860s and 70s, people recognized that the term person included the unborn. But Justice Kavanaugh, in his concurring opinion, he made it clear that he wants abortion to be a states' rights issue, and he would not sign on to that argument. So it's not likely that'll win the day anytime soon, but is it an excellent and valid argument that will continue to be raised?
Thank you. So which states, here's another question, are succeeding best in putting an end to abortion?
There are a list of states. I don't have it in front of me right now. I know it includes, I could pull it up, but there are a handful that are the most pro-life. And I do have access to it, but it's obviously Texas is on the list. But there are a number of them. Let me see here. Let's see. There, as Thomas said, there's, we're almost evenly split as a country. But
there are graphs that are available if you look that up there that show mappings where they are. But we're talking 25 states. That'd be a lot to have in your mind.
Yeah. Well, maybe we could return to that.
But yeah, Texas, Alabama, Arkansas, Kentucky, Louisiana, Mississippi, South Dakota, North Dakota, and Idaho. In those states, abortion is illegal, except in the case of rape or life of the mother. It's pretty incredible.
Mm-hmm. And what do you think are some of the potholes, someone's asking, for the pro-life movement to avoid following the overturning of Roe v. Wade?
I think that we need to be very strategic about which issues we push and which jurisdictions. We don't want to overplay our hand. And so, for example, making it a criminal offense for a woman to get an abortion if she's from a pro-life state and she goes to a pro-abortion state might be, maybe there's legitimate reasons to do that, but maybe that wouldn't be the best issue to push right now. So we want to push issues that can advance this cause. And so I think the pro-life movement as a whole needs to be very strategic. And if we overplay our hand, it can backfire. So we want to highlight the examples of where the other side is going too far. And so I know that's a general statement, but I think the other side overplayed their hand, and we don't want to make that same mistake.
Well, look, thank you very much indeed, Mr. Jonna. Thank you very much indeed, Mr. McKenna. I have to say, we do have to draw things to an end. I'm sorry, because I know that there are a lot of questions here. But once again, this has been a remarkably helpful webinar, I think. Not least for those of us outside of the United States, but I'm sure for many in the United States too. Now, so thank you for everyone for joining us today. The video of this webinar will be made available from tomorrow, I think, on the Family and Life Academy website, alongside previous webinars and courses, including a 6-part course on abortion, which is now freely available. And very soon we'll have available a 5-week course on parents as primary educators of their children. So that's something that many people may be interested in looking at. So many thanks again, Mr. McKenna, Mr. Jonna, on behalf of everyone who have seen, will see this webinar, for sharing your invaluable time and insight with us today.
Thank you very much, John, for inviting us on, and it was a pleasure to be with you and Paul today.
I agree. Thank you very much, John and Thomas.